Good afternoon and welcome to the Appellate Division, First Department. Good afternoon. Can you hear me? Great, okay.
Yes, we can.
Good afternoon. Welcome to the Appellate Division, First Department, and excuse us for those brief technical difficulties. I'm going to call the calendar and let everyone know how much time they've been allotted. People v. Michael Lamb, appellants 6 and 2, respondents 4. Wang versus Levi, submitted. Lay versus Perry S., submitted. Smith versus Green, appellants 4 and 2, respondents 3. Keeling versus Salvo, submitted. People v. Frederick Norwell, submitted. Shear Enterprises versus Cohen, appellant 5 minutes, respondent submitted. Aerotech versus MEPT 757, appellant 4 minutes, respondent 4 minutes. Correa versus City of New York, submitted. Kaufman versus Capital One, appellant 4, respondent 4. People v. Jeffrey Simon, appellant 4 and 1, respondent 5. Madrigal versus Montefiore Medical, appellant 5, respondent 6. Board of Managers versus New York City Department of Finance, appellant 7, respondent 7. Joleka versus Caban, submitted. Blasetti versus MTA, respondent, appellant 5, respondent 2. MBF Clearing versus JP Morgan, appellant 7 and 2, respondent 7. Vanessa versus Michael, submitted. Mashinsky versus Drescher, submitted. Landusco versus Open Loop New York City, submitted. Continental Insurance versus Greenwich Insurance Company, submitted. First case to be argued, People versus Michael Lamb, appellants, Mr. Kaplan and Andrew Howard.
Good afternoon, Your Honor.
Good afternoon. You may proceed.
Good afternoon, Your Honors. My name is Andrew Howard, and I am an extern at the Center for Appellate Litigation and a recent Columbia Law School graduate. Today, I am arguing on behalf of the appellant, Mr. Lamb. New York lacked jurisdiction to prosecute Mr. Lamb for sex trafficking, and relatedly, the court erred in its interpretation of the sex trafficking statute in response to a jury note. To establish jurisdiction in New York, the people must establish that the defendant's conduct occurred within the state.
Excuse me, this is Judge Mazzarelli, also from Columbia Law School, so I congratulate you. But doesn't People versus Giordano more or less settle this issue for us?
No, Your Honor. Giordano is actually not really applicable. The holding in Giordano deals with the superfluity issue. Although there is a matching statute between, the structure of two elements, which is what we acknowledge, our issue here is the nexus. So in Giordano, it was never an issue about whether there was a connection between the betting and the hedging of the bets. The issue is whether there's a connection between the two parts in the statute. Giordano dealt with superfluity, and actually, far from arguing from a superfluous interpretation, we're contending that the first prong must be read as tied to each aggravating factor, which leaves no room for superfluous language in the statute.
Has any case so held?
So held with regard to nexus?
No, putting that the two of them have to be seen together.
Both parties have acknowledged that this appears to be an issue of first impression, but in Giordano, it was clear that nexus was not an issue. The people in their response tried to talk about, one element versus two element, but from the beginning of our response, we argued that a two element crime, the sex trafficking statute. So the arguments in Giordano don't apply. Additionally, Giordano, while also the nexus was obvious, it's also a venue case. So the weight of it when it comes to jurisdiction under New York law is not nearly as strong. It is a different issue.
Okay.
But on that note, the statute must be read to require that the first element, which is the advancing or profiting from prostitution, relates to the victim of the coercion in the second element. So under the correct interpretation.
But the very nature of sex trafficking is such that you have multiple people working for you, right? So you're saying that in order to make out sex trafficking, you have to connect it to a particular person rather than the enterprise as a whole?
I think theoretically there could be a scenario in which an enterprise jurisdiction finding would be possible, but that is very far outside the facts here. I mean, in this case, Mr. Lamb's interactions with Ms. Christians were over the period of just 4 days, and any evidence putting the connection between Mr. Lamb and Ms. Christians in New York is purely speculative. The interactions occurred in New Jersey. He was responding with an email that said New Jersey winning circle. There just isn't the people failed to prove beyond a reasonable doubt conduct occurring in New York that would advance prostitution as it related to Ms. Christians. The only evidence they offered with regard to the prostitution in New York was around.
You're, excuse me, this is Judge Kaplan. So you're saying the fact that the sex trafficking scheme may be going on in New York wasn't enough to prove the first element, and then there was a second element that had to do with it. But if it was outside of New York, that's not enough.
Yeah, so it has to relate, and we talk about this in the briefs. If you use the people's interpretation, you can come up with some really kind of, absurd outcomes. You could have someone hire a prostitute in New York and then fly to Hawaii and take someone's passport there, because one of the elements, element 3 of the sex trafficking statute, doesn't even deal with prostitution at all, and then they could be charged with sex trafficking in New York. There has to be a nexus between the person being coerced and the aggravating factor. Here, none of the activities involved in New York.
Actually, I think if you took someone from New York and flew them to Hawaii for the purpose of prostitution, you'd be violating a federal statute called the Mann Act.
I agree, Your Honor. I'm saying if the person hired a prostitute in New York and then left on their own accord, not bringing that person with them, and then just proceeded to commit aggravating Act 3, which has nothing to do with prostitution, has to do with the taking of a passport or ID, they could then be convicted of sex.
How about paying the person in the foreign jurisdiction?
That would constitute promoting prostitution, but that would not constitute sex trafficking if there was no.
Well, you might want to tell a former governor of this state to make that argument.
Well. With regardless to the former governor, the nexus issue here is quite clear. And regardless, even if this court finds that there could be jurisdiction on the alternate attempt or other, finding, because the court in their jury note misinterpreted the statute, at minimum there should be a new trial because the jury could have found on illegal grounds. That brings me to my next point, which is the second issue on appeal. The court erred when it failed to grant a mistrial to Mr. Lamb after it adjourned the jury deliberations for over 24 hours without effective consent in violation of CPL section 310.10. There's no argument.
You concede that the defendant had agreed to not work on Friday and Monday, correct?
No, Your Honor. There was a conditional waiver, which if you look at the record, it is very clear.
What part of the language was conditional?
It was that defense counsel said.
Exact words. Tell me what exact words made it conditional.
They said, if the jury is still deliberating at the end of the day on Thursday, then we would consent to Friday and Monday. So that was the conditional language.
Because somehow the funeral that the defense counsel had to go and travel to on Friday throughout the long weekend changed?
I highly doubt it changed, but we don't have any sort of.
It's impossible that it changed. Somebody died. Somebody died. right?
100%,
And
but-
part of the entire adjournment request was at defense counsel's urging.
Yes, Your Honor. But as you know, in law, there can be issues in which personal matters, get subjugated to the issues of the client. It was a conditional waiver based off the events, but had the client's rights been at stake, and we don't know. It's purely speculative as far as whether the attorney would have, made that sacrifice for her client. But
Well, did she say that? Did she say on the record that she would, so that it would have provided the court an opportunity then to call upon the jurors to come back on Friday, notwithstanding the promise to the jury?
I believe within the framework of the Thursday objection that morning, it said that the condition, for all effective purposes, through that objection and demanding for a mistrial, I believe that effectively did.
No, no, not effectively, because you can't have it both ways. You can't say, Judge, I didn't agree to 3 days worth of adjournments, because then the only alternative the court had was to call the case again on Friday and continue deliberations on Friday.
Yeah, yes, Your Honor, and that was not an option given to counsel at the time.
Was it a request made? I mean, the attorney made the application.
I understand that, Your Honor, and based off my understanding of the record, it did not come up because it seemed like the juror was not likely to come on Friday either. So I think within the context, it did not make sense of that matter to bring up the Friday option. That said, the attorney had a timely objection.
What on the record left the impression that the juror would not be able to come back on Friday, since the reason that the juror was not there was for a job interview. Job interviews don't typically take 2 days.
True, but it was in Vermont, and so I believe he was traveling for the interview on the next day.
That's a couple of hours drive.
I recently did the drive, but it was on the Thursday and the Friday, and I do not believe the court gave the option. It is unclear from the record whether on Friday that would have mattered, but regardless, it does not obstruct the fact that defense counsel gave a conditional waiver, and that condition was not met, so there was no waiver, and under the strict interpretation of the statute, that is a violation.
Okay, we will hear from you on rebuttal.
Thank you, Your Honor.
I don't want to mangle the last name. Croes?
Good afternoon, Your Honors. John Croyce. For
Croyce. My
Everybody
apologies.
Does. Also from Columbia.
All right.
To start with the jury separation issue, I think the fact that it was for a funeral pretty much resolves that as a matter of common sense. But, Your Honors, I would point to one other thing, too, which is that this separation that was agreed by the parties in the court was discussed off the record with Justice Pickles. So when they come back on the record on Tuesday and defense counsel raises exactly the argument the defendant is currently raising, Justice Pickles, who was there, made a factual finding that what defendant is arguing now is not what happened. Justice Pickles said, this is just gamesmanship. I know what you're doing. You didn't make a conditional waiver. So, Your Honors, in addition to the common sense aspect of that, I think Justice Pickles' factual findings, since she was there, that there wasn't that condition, is more than enough to dispense with that.
If we were to eliminate the Friday and Monday, how many hours from Thursday to Tuesday elapsed?
It is 24 because of the exact way that they worded it. They were very careful. They understood that they were making this waiver and they knew the strictures of this law, right? They made the waiver from around 4:30, close of business on Thursday, specifically to be able to effectuate this. So when on Thursday morning, there wasn't a juror present, he was in Vermont, they couldn't get the juror back, adjourning to 24 hours, which is the outer limit of the statute, puts you within the consent time, because the consent time is running from the end of business Thursday. And then it's the 24 hours that's permissible, brings you to the end of Thursday, and then you've got Friday, Monday, gets you the rest of the way. So it's a combination of the inherent power of the court and the consent that the defense counsel agreed to for the funeral. Now, on the jurisdiction point, Your Honors, I think Giordano controls here. This statute is clearly modeled after the anti-gambling statutes. It's set up essentially identically, the same issues presented with the first element, which if you read that first element as unified with all the other elements, then the first element becomes superfluous. And the exact kind of argument about, well, what does the word by mean in this statute was resolved by Giordano 20 years ago. So, Your Honors, I think that that is decisive here. But I would also note that even if you were to find that Giordano did not apply here, we still had an independent basis for jurisdiction under 2021A, which is that defendant committed literally thousands of acts in New York manifesting his intent. Intent was an element that we had to prove. And so however you construe the relationship between the elements in the statute, even if you construe it as one indivisible thing, well, we showed with evidence of defendant's acts in Manhattan, with his emails in and out of Manhattan, that he had the intent to advance or profit from prostitution. So we had multiple bases of jurisdiction here, Your Honor. I think New York had the right to hold defendant accountable. If there are no...
But counsel, the sex trafficking counts that he was charged with dealt only with Miss Christians. And it seems from the testimony that I read that everything involved with Miss Christians occurred in New Jersey. And so how could there be an appropriate nexus with the fact that, you know, maybe he was there was a scheme here in New York and he was advancing or profiting from it from New York, but the sex trafficking convictions had to do completely in New Jersey. So that's where I'm lost a little bit. I think in Giordano, the connection was a little bit more clear, as I think Mr. Howard pointed out, and I seem to agree in reading that case.
So, Your Honor, I think approaching it with Giordano in mind, I think what we have to recognize here, and I think the facts, this leaps off the page, this is one business. This is not two separate LLCs, one in New Jersey, one in Manhattan. And we know this because we had witnesses testify that I think it was Santangelo, Jennifer Santangelo. Yeah. She was recruited in New Jersey and defendant was advertising her, against her will, by the way, but advertising her sexual services in Manhattan. We also have it going the other way. We have Miss Taylor was recruited in New York and her services were advertised in New Jersey. So, you know, the nexus is that this is one business. And I think this goes back to why...
Can I ask you a question? Was there any evidence with regard to whether any of the ads that would send a user to the New Jersey site were seen in New York?
When you say New Jersey site, Your Honor, I'm sorry, are you referring to...
One of these sites was New Jersey something or other, right?
There are a lot. So defendant...
And according to the record, it was that New Jersey named site that was utilized with regard to Miss Christians. Is that right?
I see what you're saying.
So that site, right? The ability to access that New Jersey site wasn't limited to just New Jersey people, was it?
No, it was not. And Your Honor,
so New Yorkers were able to access that site and perhaps try to obtain the services of Miss Christian through that site from New York?
Absolutely, Your Honor. I mean, defendant ran his own website, which described his business as a tri-state area thing. And as to the New Jersey site, I think Your Honor is referring to the NJ Exotics email that defendant used to contact Miss Christians. Well, we know that that wasn't limited to New Jersey because there's evidence on the record that he used that to recruit people from Manhattan and to advertise them into Manhattan. It said New Jersey in the title, but practically that's not what he was using it for. So the fact that he contacted her from that address doesn't really matter. And I think it goes back to the fact that this is one business. And the legislature knew this, right, when it was writing the statute. These businesses, they cross state lines, they cross international lines, but they are businesses. And so if you commit an act that furthers your business in New Jersey, but you are also advancing prostitution in New York, and that is something that we can hold you accountable for, I think, under the sex trafficking law and under Giordano. If there are no further questions, Your Honor, thank you very much.
Thank you, Mr. Howard. You have 2 minutes. We don't hear you. You have to turn on your mic.
Thank you, Your Honor. Sorry, can you hear me now?
Yes.
Yes. So first, with regard to Giordano, the people are mischaracterizing our argument. We are not arguing for a superfluous interpretation. In fact, our interpretation requires even less superfluous, and we're arguing the nexus. So Giordano is not holding. Additionally, I want to point out the rule of lenity. This is an issue of first impression. There's a lot of, there's different ways of statutory interpretation, and as a principle of law, these statutes, when it is a plausible interpretation, should be found in favor of the defendant. As to the points regarding Santangelo, I want to point out that defendant was acquitted with all the charges to Santangelo, and even in the people's factual report, he's trying to paint out this giant business of my client. Santangelo didn't even want to get involved with my client because it was so small time. This idea of this giant business is a complete mischaracterization of the facts. The reality is the people presented a lot of evidence of the 2013 interactions in New York, and it got very sparse when it comes to the time of Miss Christians. With regard to Miss Christians, there was 4 days of interactions entirely within New Jersey to a New Jersey email. As far as the speculation on the people with regard to, a business and all these other things.
Let's wrap it up.
Sorry. With regard to that speculation, that's what it is, speculative. There's no evidence tying that coercive act, and so long as there needs to be a nexus between the two statutes, there's no jurisdiction. But at a minimum, there should be a new trial because it could have the jury could have found under the illegal grounds. Thank you, Your Honors.
Thank you so much. Okay. Smith versus Green, Jillian Rosen and Mr. O'Shaughnessy.
Good afternoon, Your Honors.
Good
Jillian
afternoon.
Rosen for the plaintiff appellant. Can you hear me?
Yes.
Okay, thank you. I did not go to Columbia Law School. I hope that's okay. I haven't. But in any event, our position on this appeal is that the plaintiff raised an issue of fact as to a significant limitation and a permanent consequential limitation as to plaintiff's shoulder and knee. And both injuries were completely thrown out improperly. For example, Dr. Goldenberg provides contemporaneous decreased range of motion values for the knee and for the shoulder. And that's at page 218 to 223 of the record. More importantly,
Ms. Rosen, can I ask you a question about the left shoulder? The plaintiff had surgery on his left shoulder in May 2016 by Dr. McCullough. Is that correct?
yes, sir.
And didn't sometime after the surgery, didn't Dr. McCullough see him again and report that he had, he was much better. So, his surgery went well. So, I mean, even if there might be something with significant, the permanency issue I have a question about because of Dr. McCullough himself, his own findings.
Well, what's interesting about that, Your Honor, is that is the 90% is self-reported. And so oftentimes when you have a situation where the plaintiff comes in and says, I'm really injured, I can't move my arm or my leg, and then the doctor actually finds objective evidence that they're not so restricted. You go with the objective finding on the goniometer. Here we have a situation where the plaintiff may have said, I'm feeling a lot better. And Dr. McCullough did recognize that he had significant improvement, but it's not fully resolved. Dr. McCullough actually found in November 2018, 140 over 180 in the forward flexion of the shoulder, which is a 22% deficit. So I understand where the plaintiff said, oh yes, I'm definitely feeling better. And that's great that he was. And Dr. McCullough recognized that. But at the same time, he recognized that it has not fully resolved. And it still results in, he still claimed it to be a permanent partial disability and that his activity of daily living is restricted, will continue to be restricted. He'll have to continue modifying it. So I think the fact that the plaintiff said, I'm feeling a lot better, I think that you need to go just like we do when it's not in plaintiff's favor. We need to go with the objective evidence. So in addition to the surgery and finding these tears on the surgery, in the months subsequent to that, and even through January 2017, which was the last visit with Dr. McCullough, he was evidencing an 11% restriction, and then in November 2018, when he saw him again, the most recent exam, it was actually worse. It was 140 over 180. So that's how I would address that issue, that we're glad that the surgery helped him, but plaintiff's own surgeon testified. I mean, I'm sorry, not testified, but he submitted an affidavit, and in his records, it reveals that he's still very, very restricted, and everything is with pain. So that's another distinction to be made here, that he's in pain every time he makes that motion.
All right, thank you. You'll have time in rebuttal.
Oh, thank you.
All right, Mr. O'Shaughnessy.
Can everybody hear me?
We can now. We can't
Okay.
see you though.
I'm sorry, you can't see me?
No, not yet.
All right, how about now?
Let's give it a minute. I think you're coming in.
All right. I was here.
There.
Is there something in front of your camera?
No.
We have a black screen. There you go.
Oh, I'm sorry. Is that better?
It came in and went out.
Okay, hold on. How about
There
now?
you go. Now, you may proceed, sir.
Thank you. Good afternoon, Justices of the Court. My office represents Heather Green, the respondent in the case. I think some of the points that have been raised by the justices herein really are hitting the nail on the head. What's important to note is Dr. McCullough, which is the plaintiff surgeon in the case, he is the person who we want to know from, right? He's the person who opened up the plaintiff. He's the person who peered inside and is able to see what's going on with the shoulder, which is really the main injury in the case from plaintiff's perspective. If you look at what Dr. McCullough states in the post-surgical follow-up on August 12th, which is 8 months after this accident and only 3 months after the surgery, yes, there are self-reported improvements as stated by Katie and Smith. That's true. But the range of motion testing is done by the physician. It's not done by the appellant patient. When you look at that range of motion, again, this is 8 months after the accident, 3 months after the surgery, what you're finding is deficits of about 6%, 170 degrees out of 180 degrees in forward elevation, and external rotation is 75 to 80 degrees, with 80 degrees being normal, roughly again a 6% decrease. That 6% decrease can surely be characterized as a matter of law as minor, mild, or slight. And in that respect, the shoulder injury was correctly dismissed by the lower court. When you're looking forward in time, and now you're getting later on with Dr. McCullough, again, the same surgeon who looked at the shoulder, he's now looking at it October 11th of 2016, which is 10 months after the incident or 5 months after the surgery. And then he sees him again 13 months post-incident and 8 months post-surgery on January of 2017. Both of the studies are, again, mild restrictions of about 11% and 6% respectively in the various planes. I'll submit to the court that these are, again, mild, minor, or slight, and that the lower court absolutely got this right. Thank you.
Why do you ignore the November 2018 report?
Well, I don't.
Why is that irrelevant?
I won't ignore it. If you do look at that report, which is at record of pages 200 and 201, there are no positive objective tests therein. Range of motion, most plaintiffs, most appellants who are plaintiffs will argue that the range of motion is subjective and the objective tests don't lie. Well, the objective tests herein in November of 2018 were negative. None of them were positive. So to the extent that that is relevant, I'd say that in November of 2018, the plaintiff was whole.
So the 140 versus 180 is normal?
No, it's not normal. That's a subjective finding at that time. And it really begs the question as to what occurred between that interval the last time.
That wasn't subjective. That was Dr. McCullough who recorded those ranges.
I understand that, Your Honor, but when I'm saying subjective, most people will say that range of motion testing is subjective in that the patient has the ability to alter or change the level of input they put in. An objective test is an objective test.
Because every patient malingers, right? Every patient is faking their injury. Nobody who has a motor vehicle accident is ever hurt.
Not at all. That's not what I'm saying.
I mean, that's what you're saying. So if there's ever a positive range of motion test, it must be because the patient is lying.
Not at all. What I'm simply suggesting is if the court is to look at the objective tests, the tests where they're either positive or negative, there are no negative tests at that on that date.
Okay.
Thank you.
Ms. Rose.
Thank you, Your Honor. Sorry to interrupt you. Just with regard to a positive test, I would like to point out, most notably, on July 9th, 2018, so only a couple months before McCullough's November 2018 report, defendant's own expert, Dr. Glassman, finds a positive Hawkins impingement sign in the shoulder. That's a lesion in the shoulder, and it's a positive orthopedic finding that is an evidence of serious injury. So their own expert finds this 2 months before November. So I just want to point that out because my adversary talks about no positive findings in the shoulder, and there most certainly is by his own expert. But I just want to spend my remaining seconds or minute with regard to the knee very quickly. My same position on page 200 of the record, you will see McCullough talks about a decreased range of motion, which is 13% in the knee on page 200. It's 130 versus 150. And there's an equivocal Murray sign, which is also a positive orthopedic evidence of a serious injury. So that's our position on the knee. I'm going to skip over the back. I think that's our weakest link, and we still have the back in as to significant limitation. The last thing I'd like to point out is this 90 out of 180. What's really interesting on this is that just recently, this court in Reed, it's 2020 New York Slip Op 05247, Reed against Edwards Grant, addresses the very issue that's here on 9180, where you have a situation where we recognize that he went back to work right away, but that's not dispositive. The defendant was never asked to identify at his deposition any usual and customary daily activities that were hampered or affected or changed within the first 90 of the 180 days following the accident. And under this court's precedent, this case Reed was just decided on September 30th, that the defendant fails to establish prima facie case under 9180 based on that very fact. And if you have no further questions, I'll rest on my brief.
Thank you so much.
Thank you very much for listening.
Shear Enterprises versus Cohen, Mr. Eli Fiat.
Fight. Do you hear
Fight.
me?
Yes, I can, and my apologies,
That's
Mr.
okay.
Fight. You may proceed.
Good afternoon, Your Honors. What happened here was that the IIS court denied our motion to dismiss the amended complaint in a one-sentence decision that failed to explain how this court's leading case on pleading a fraud claim arising out of a contract, which is the Kronos Group case, and that case held that a fraud cause of action against the individual officer of a corporation was duplicative of the contract cause of action between the two corporations, excuse me, because the oral representations there did not allege a breach of duty that was collateral and extraneous to the contract between the parties was any different from this case. And we submit to Your Honor that this case is no different. The fraud claim here against my clients, the individuals, pleads no specific facts against the individuals. It's only conclusory language that my client made promises, and we'll see in a moment that each one of those misrepresentations relates directly to the contract between the two corporate parties. Now, they allege that...
Well, excuse me, Mr. Fight, I mean, didn't the plaintiffs allege that the individual defendants who ran Trejoli, the company, got this $110,000, the second payment, and then the next day the business allegedly went out of business, and the plaintiff alleges that they used this money to assist in paying off other things, but not for their orders. So, I mean, they didn't do what they said they were going to do, and that may be something above and beyond. There is a decision from this court in 2019 that I happen to have been on now, where we said, look, it's just a motion to dismiss and let's see what happens. But we sometimes allowed fraud to be pled in the alternative if and it's not necessarily duplicative. I never had a fraud case where I haven't seen somebody arguing it's duplicative, but sometimes it is and sometimes it's questionable, and we don't want to dismiss those on 30-11 motions.
Right. I understand that, Your Honor, but the allegation that that they closed down the corporation is so far removed from the original contract and the original alleged misrepresentations. So one has nothing to do with the other.
Can there be only one misrepresentation?
Well, there can be only one.
It seems to me like there are several here.
Yeah, but each one of those representations relate to the primary contract between the two corporate parties. There are no specific facts alleged that my clients did anything or benefited in any way. In fact, the proof is the other way. For example, we know from.
I'm sorry, they paid out a lot of money and got nothing back, right?
Yeah, but they paid
So
it out.
how is it that you made out worse than them?
They paid it out to the corporation. We have a different theory as to why there's no claim against the corporation, and that I'll speak about that in a moment. But as far as a claim against the individuals, we were operating in the corporate form. All those representations relate directly to the essence of the contract. I mean, what did they say? They said that that we intended to hold a deposit to secure plaintiff's full payment of the orders, that Trey Jolie was financially sound and had the financial ability to properly and timely fill and ship the orders. That relates directly to the contracting parties, that the plaintiff, that they didn't have to worry about the orders or the down payment, and that both would be secure. That relates to the main contract between the two parties. And then they say plaintiffs should trust them based on the years of doing business together. I just might want to point out they've been doing business for over 10 years, and all of a sudden my client made these kinds of representations. I think we have to take it a little bit with a grain of salt, even though I understand that on a motion to dismiss, we take the allegations of the complaint as true. But they're a little bit of far-fetched here, especially if you look at the documentary evidence that we put in on the motion to dismiss. What happened
Judge
here?
Mazzarelli, you have to unmute.
Hello. That may seem that way to you, but the fact is, according to the plaintiff, they paid over $400,000 to your client in 2 installments, the last one being $110,000. And shortly after that money was received by your client, they went out of business, and the plaintiff didn't get the clothing, the material goods, and didn't get any money back.
Your Honor, that may be correct, but that doesn't give.
No, that is correct. Is there an issue about that?
That's what's pled, Your Honor. So we have to take it as true.
Did you say that did your client say that they gave the money back? This is not true, because we reimbursed them for the items we never delivered. Is there anything like that in any of these papers? I didn't see that.
Your Honor, we gave them credit on 25%. There was a new deal made after the contracting parties, the two corporations, made an agreement. And that's why we claimed there was a novation, because the documentary evidence, which is, by the way, not refuted.
Now you're talking about the second payment, the $110,000.
No, I'm talking about the first payment, Your Honor, the $335,000.
Yes, you said you gave them a credit, and then they gave you another $110,000.
Yes.
And they didn't get anything after that either.
Your Honor, but that doesn't transform it into a personal claim against my clients individually.
Well, the allegations are that your client made certain representations personally.
Your
right?
Honor,
that's the allegation.
There is no allegation that my client made any representation for anything for personal benefit. They are only related to the corporation acting and carrying out its contract. According to the
Okay, sir, you have to wind up. You're out of
Yes.
time.
So we put in documentary evidence that shows, and there is no allegation in the complaint, for example, that claiming tortious interference as a separate cause of action. They allege in conclusory language that we obtained a personal benefit. There is not one single fact to prove that we obtained a personal benefit.
What
We're
about
allowed to-
this is Justice Molden, paragraph 96, it says in the complaint, they're alleging that the two Cohens took the money to reduce their personal guarantees to Treasurer Lee's factor. So that's pretty specific about a personal benefit. That's in paragraph 96 of the complaint. So that's enough to get by a 3211 motion.
Yeah, but Your Honor, the fact that a corporation pays down a corporate debt and it has the effect also of reducing the individual's liability, I don't think transforms a corporate claim, cause of action, into an individual fraud claim or tortious interference claim.
Thank you so much.
Otherwise, you could
Sir,
never do.
Thank you.
Yeah.
Thank you
Okay.
so much.
Okay, thank you.
Aerotech versus MEPT 757. Mr. Spawn, you have 4 minutes.
Good afternoon, Your Honor. Initially, I'd like to reserve 2 of my minutes for rebuttal if the court will permit it.
Okay.
Thank you,
You got
Your Honor.
it, 2 and 2.
Okay. Just briefly to touch on a few points, because I know that the panel is familiar with the facts. We're dealing here with 2 identical leases negotiated jointly for subsidiaries of Allegis Group. These leases are identical in all respects: rent per square foot, tenant improvement allowance per square foot, etc. They're also identical in that there's nowhere is there a requirement for the separate submission of the supporting documentation for the tenant improvement allowances. I would ask my adversary to cite chapter and verse as to where he claims that is in a lease. He can't, because it's not there. If, in fact, if we're so clearly there, the old landlord would not have been required to indemnify the new landlord in the purchase and sale agreement of the building. Rather, this requirement for the separate submission of paperwork was judicially crafted in violation of clear, well-settled law against interjecting terms into leases and not interpreting them according to their terms.
Mr. Spahn, can I ask you a question? So even if that we could possibly interpret the contract to require separate submissions, you put all the information there before the 18-month cutoff date of January 1st, 2015. Like, you had made a submission by December, hadn't you? So they had all the material. It might have to have just been sort of reformulated or reorganized a little bit.
Absolutely, Your Honor. In fact, we're taking the position that it was one master key that unlocked both locks. These documents were legally operative to satisfy both separate leases and their obligations. One lien waiver would defeat a mechanics lien against the 8th floor, the same way it would defeat a mechanics lien against the 12th floor. It's also further undisputed that the contractors were fully paid and the project is lien-free. The construction was completed according to landlord approved plan, and the tenants paid over $2 million for these renovations. In fact, the landlord received a $2 million credit in the purchase and sale agreement for these tenant improvement allowances, and now the landlord's trying to keep a windfall by trying to keep the tenant improvement allowances.
Okay, you can finish up on your saved 2 minutes, okay?
Thank you, Your Honor.
Okay, Mr. Berman.
Good afternoon. May it please the court. My name is Mark Berman. I represent the defendant respondent 757. Respondent seeks affirmance of Judge Scarpulla's grant of summary judgment in favor of the landlord and denial of summary judgment to the 2 tenants. She was correct, Your Honor, on summary judgment, Justice Scarpulla, when she said, I note each lease had a different TIA maximum allowance, and nothing in either of the leases permitted plaintiffs to submit a combined TIA. There is no, as you hear in the brief from the appellant, there is no condition precedent. There is not a direct one. There's not an inference. There's not an indirect one. We have 2 leases, Your Honor. There's no cross-pollination, cross-default.
But wait a second, Mr. Berman, weren't these two leases negotiated together, and weren't these parties together on one floor, and then they got new spaces, one on the 8th or one on the 12th, I think. So they're, you know, they did have some connection. It wasn't like they were two completely separate tenants.
They were two subsidiaries of a parent on two non-contiguous floors, Your Honor. That is correct. Different space, different portions, different.
But they had been together was the first part of Judge Kapnick's question.
At one point, I believe they were together. Yes.
Right. Okay.
But this is not a case of a con or a hoodwink, as we tried to see in the papers. Your Honor, this is.
Counsel, there's no question that the requests were submitted on separate letterheads in one FedEx package before the deadline specified in the lease. And really the issue here was that some of the invoices reflected overlapping work. Why should that be fatal to the plaintiff's claim when in essence, what they were required to provide was indeed provided?
It was not provided, Your Honor. 6.5B says you need proper receipts and original unconditional lien waivers for that portion of the initial alterations. If you look at record page 77, what does it define as initial alterations? It speaks to the approved plans and specifications provided to the landlord for such initial alterations. The approved plans. The point here, Your Honor, is when you get a package, the package goes to the lender to do an audit, and what they see in this package, package A and package B, has the same thing. They say 55% on one, 45% on the other. That's not the point. The bank, the lender, as demonstrated in our affidavits, looks at it, audits it, checks to see if the work's done. They can't check.
Wait, can I interrupt you for a minute?
Yes, Your
I'm
Honor.
sorry, Mr. Berman. I mean, I know that's what you said because you had to satisfy the lenders, but that really wasn't part of the contract that you had with these two separate tenants. I mean, you wanted the information. They didn't necessarily have to do it, because of the lenders. I understand that might have ultimately been the reason, but I don't see how that should affect the tenant's responsibility.
But the landlord in the agreement on record page 77 is to look at to see if the work is done in accordance with the approved plans for that floor. They can't do that with a mishmash.
But wasn't the work, I mean, there was no problem with the work. Didn't they do it timely? Didn't they do it according to the plans? Was there any indication that
they did the work timely? They did it when they were supposed to, and they were supposed to submit segregated documents supporting each TIA for each different lease.
So you're saying, because I'm trying to understand, I'm sorry, Judge Moulton, you go ahead. I've had a chance.
Well, I was just going to mention that the lien waivers, all of them said that they applied to both floors. So what's the problem? Just make an extra copy of the lien waiver.
But it's not about the lien waiver, Justice Moulton. It's about what specific work was done on what specific floor. Because, and that's not made up, that's what's required by the lease. If you look at record page 77, it's according to the plan.
Plans tell you what work is being done on each floor, no? You are suggesting, because what I'm hearing is, if this particular tenant, who for all intensive purposes is one and the same because they have the same parent. So if there's money being expended for these two subsidiaries, it is very likely that it is the parent that's shelling out the cash for this build out. And you're basically saying if they needed cement boards for the 12th floor, they had to do one purchase order for the 12th floor cement boards and another purchase order for the 8th floor cement boards to be in compliance? To make it easier for your lender to break down the cost?
I'm saying it's appropriate for my lender needs to break down the cost and the landlord needs to break down the cost to audit what was done. You can't do it when it's all together, when it says I did 100% of all the work for these non-contiguous leases and what was done. That's not, it's not what the strict requirement of the contract provides for, Your Honor. It's
Mr. Spawn said earlier that you would not be able to point to any section of this agreement that spells out exactly what you've just said, that this documentation had to be done in the way that you were suggesting it has to be done now.
actually, Mr. Spawn said that I cannot point to any place in either agreement where it says that they must be separate. That
They must what?
They must be provided separately. And the answer is you have two agreements. The default is not a mishmash, a combined. If we were to allow combined, the provision would have been there. He has it reversed. You start with two independent contracts, and each has to be complied with independently. There is no provision that says you could do a combined. So when he says it's not there, there is no condition that it has to be separate. There's no condition that it has to be together. The answer is, what is the default? You comply with each one separately. What I did point out to the court, Your Honor, Justice Manzanet and Justice Kapnick, is when you look at the agreement. You look at the agreement on record page 77. You have to see the work and look at it. Was that work done for that floor in compliance with those plans? And you can't tell that when everything is done in a mishmash fashion.
Okay, thank you. Thank you. Mr. Spawn, you have 2 minutes.
Thank you again, Your Honor. And the point was hit on the head by Justice Kapnick about Mr. Berman invoked repeatedly the lenders and the provisions that how the lender wanted things segregated. These leases were drafted chiefly by the landlord, and these leases are silent as to any obligations relating to the lender. If the landlord didn't put it in, quite frankly, that's the landlord's problem. What I have is a Mr. Berman derides it as a mishmash, but let's talk about how that mishmash got started. They were joint communication. First of all, you're absolutely correct, Justice Manzanet. This was a joint negotiation by Allegis Group on behalf of two of its subsidiaries, and the landlords at all times treated them jointly, including during the project, joint communications between the tenant and the landlord
Didn't you tell them that you were doing this together? I mean, wasn't there communications during the period of time that you were kind of considering this like one project?
Absolutely, Your Honor. Record 826.
You had the same contractors and the same architects and
yes,
working on both floors. Is that correct?
Yes, Your Honor. And moreover, the landlord issued a joint invoices for building services, elevators and security and whatnot. If this were separate projects, why is the landlord issuing joint invoices? The landlord treated it the same way. The landlord should not then be able to, for convenience and keeping a $2 million windfall to frustrate a condition and then cite to the condition. That violates this court's holdings in VXI Lux Holdco 171 Appellate Division 3rd 189 and its progeny. And clearly the landlord should not be able to do that. Further, as to the ipso facto argument that Mr. Berman raised, there's nothing cited in support of this argument. He's He's claiming there's nothing in the lease which provides it for a joint submission. There's also nothing in the lease which prohibits it. What I've got, and Justice Moulton referred to it, I've got a master key that opens both locks. One set of documents works for the 8th floor. The same set of documents works for the 12th floor. This is form over substance. In closing, I would implore the court to not permit a form over substance issue to permit the landlord to gain a $2 million windfall when my clients set forth that money, and it's undisputed that they paid that money.
Thank you so much.
Thank you, Your Honor.
Kaufman versus Capital One, Evie Kazansky.
May it please the court. My name is Evie Kazansky, and I represent Capital One and 250 Tenants Corp. This case involves a labor law case where we moved to dismiss the 200, the 240, and the 241-6. 200 and 240 were dismissed, and at issue is that the lower court found that there were questions of fact regarding whether or not there were violations of 241-6 under the predicate of 1.7e, whether it be 1 or 2. It's our contention that the lower court was wrong, and we're seeking reversal of that portion of the decision, that no matter how you analyze the situation, whether it be 1.7E1 under a passageway or 1.7E2 in a open area, they are not a predicate for a violation. And this is because the facts of the within case are not applicable because the plaintiff himself, number one, did not trip. We did argue in the first instance that the plaintiff doesn't really know what caused the dumpster that he was pushing in front of him.
Sorry to interrupt, this Justice Moulton. I mean, it seems like Sansino kind of controls on E1. Can you distinguish Sansino?
Okay, Sansino, which is the case that the plaintiff discussed, I would argue that, first of all, the cart fell over plywood that was lying around, and also there was an issue of the passageway. Here, this particular case is quite distinguishable for the fact that the plaintiff's dumpster, first of all, the plaintiff himself did not trip over anything. So let's make that clear. The plaintiff is claiming
that's not necessary, but continue.
Understood, but I just wanted to be clear that that is the first issue. With respect to Sansino, it was clear that, number one, the plaintiff made violations of the dumpster itself, which there is no claim of a violation of the defectiveness of the dumpster. And number two, the cart fell over pieces of plywood that were in the middle of the area. Here, there's no such allegations. The plaintiff was pushing a mini dumpster to the threshold of a door, and the door itself, it's clearly framed, it's a regular door, and the issue is whether or not this door saddle is possibly a protrusion. We would argue that it is not a protrusion under the case law of the First Department. It is within the door frame. There is no proof or any question of fact raised that the door saddle itself was anything other than a door saddle sitting properly.
Excuse me, do I have my, yeah, I'm not muted this time. Didn't we define a sharp protrusion in Leonard versus 1251 Arms to include any projection that is sharp in the sense that it is clearly defined or distinct? And wouldn't a door saddle or a threshold, as it used to be called, constitute such a sharp projection?
Interestingly, I can distinguish Leonard, and I can also bring up a case where you didn't find a sharp protrusion where someone fell in a nail, and that was Mooney, 179 AD3D 490.
We don't have the nail here, so that's
right. And that both
not the issue.
What I would say
about thresholds or door saddles, I think.
What I would say about Leonard is, because I reread it knowing that possibly you would bring it up, is that the door stop at issue was in the middle of an open area with no door frames or nothing. It was basically what you would argue is a piece of debris or a sharp protrusion with nothing around it to give it a context.
But we used a broader terms in the definition in that case. We said in the sense that it is clearly defined or distinct. And a door saddle, as you know about construction, we all know what a door saddle looks like. It's pretty defined and it's pretty distinct.
I would say to you that it's not necessarily a sharp projection. Number one, the reason why it's important that the plaintiff didn't fall is because the sharp projections that you have been defining as sharp projections have actually
didn't fall because the cart got stuck on the saddle. So he was on the other side of the cart.
The saddle itself, there's nothing to say that
if the cart cannot maneuver over the saddle with the kind of force that the plaintiff was generating to move this dumpster filled with debris, then doesn't that sound like some kind of protrusion that is readily discernible that seemed to have stopped the movement of this item?
Respectfully, I would say to you, because it's in a door frame and people are going in and out of the door without falling, the plaintiff, this is the only entrance in and out of the property. So to say that it's a sharp...
But this is a construction area. It's not like it is a property, but it's a construction area. He happened to be the only one there, and I thought that there was testimony there that there was a little bit of a rise leading up to the door saddle, and he was the only one there who's pushing the dumpster out, and it got stuck, and that's why it fell over on him, and he was injured.
The testimony by him is
maybe that's not how it'll end up, but that's what he's claimed.
The testimony by him is that he's pushing the dumpster, what he believes to be upper rise. He's trying to get it over the door saddle. With respect to the door saddle itself, he does not describe that the door saddle is anything other than, he doesn't even know what the door saddle looked like. He can't describe it. So the question, what you're asking me is whether or not a door saddle is always going to be considered a sharp protrusion? No, not necessarily. A door saddle still would at some point need to be pushed over. Even when you are walking over a door saddle, if it's flush against it, you still have to step up your foot. The point of a door saddle is it is raised a little above the ground. So to say automatically that it's a sharp projection, that there was nothing jagged about this particular door saddle that could have necessarily, we don't know why the wheel was caught. He doesn't know. He's presuming and giving him all favorable inferences. That's where it got caught. So to argue that it is a sharp projection in the middle of a construction site, which is what all the other cases are implicating, whether or not that they're in the middle, they're left out, this is just a typical part of a door that he's pushing forward, and for whatever reason, it was the dumpster could not get over it, whether it was because he was pushing it, which we can't really consider, whether or not it was anything. Thank you.
Okay. I know that the respondent asked for time, but because it was a belated time, I don't know your name. Is there someone here for respondents on Kaufman? Okay, I guess I was wrong. Thank you so much.
Your Honor, please.
Yes.
The George Ilkert, I had problems with my microphone.
Okay, good. I'm glad you got through. Mr. Ilkert, you have 4 minutes.
I'll be brief. May it please the court. The evidence introduced below about the threshold states that the flooring had been removed and it was 2 inches high, which is a sharp projection. I believe the record below amply describes the facts, and as to the occurrence of the accident, it's plainly covered on the Sansino and the Piccione cases. I have nothing further unless you have questions.
Any questions? Thank you, sir. Have a good day.
Thank you.
Thank you.
People v. Jeffrey Simon. Mr. Elliott, you have 4 minutes.
Yes, good afternoon, Your Honor. May it please the court, Whitney Elliott of the Legal Aid Society for the appellant Jeffrey Simon. This court should reduce Mr. Simon's prison sentence by 1 year for 3 basic reasons. First, when he committed the offense resulting in his current sentence, he was only 19 years old, and at that point had already experienced significant trauma and hardship in his life.
Yes, and he had also, if I have the timeline correct, he had also shot someone.
That's true, Your Honor. That was the case that resulted
we have one shooting of a 12-year-old child on the street, and your client, in much somewhat bewilderingly, gets a YO adjudication for that. And now we have your client stabbing a separate person. And you're asking us to reduce that sentence for 1 year? I mean, I understand he's a young man. I understand he had a difficult life, but these are 2 people who are victims of very violent crimes that will leave them permanently scarred. This is a 12-year-old child who was shot in the leg because your client took a gun and shot into a group of people.
That's true, Your Honor. So I guess one thing I would say about the first offense, and I think that this is kind of suggested by the other side, that that somehow disentitled him to a sentence at or closer to the minimum for the second one. But I think the YO
What's the minimum for the second one?
5 years, Your Honor.
And what did he get?
6.5, Your Honor.
And what's the maximum?
I believe 25, Your Honor.
Well, isn't 6.5 at or close to the minimum of 5?
It is closer to the minimum than the maximum for sure, but it's
a whole lot.
But
I forget my basic math. If you deduct 6.5 from 25, you get more than 1.5 years difference.
I agree. That's true, Your Honor, but I think that there's sort of the sense of the argument on the other side, and I think this was even suggested by the sentencing court that that the minimum was just off limits. Now, in terms of the YO case,
yeah, he did say that. Judge Mogilescu, who your client was very fortunate to be in front of, did indicate that. Yes.
So I just do want about the first offense. I do want to say I don't think it's fair to suggest that was like an inappropriate windfall that my client got. The prosecution very much opposed that, and that was litigated with some zeal by both sides, and the court found that he was eligible for the YO and that he merited it as an exercise of discretion because he committed the first offense. There were mitigating circumstances bearing directly upon the manner in which he had committed it.
He shot into where your client took a gun and he shot into a group of people, intending to end the life of a particular person. He missed. He wasn't a very good shot, and he hit a 12-year-old child.
But there was still a finding below that there were mitigating circumstances that he committed that offense after having experienced threats for not only on the night of that incident and shortly before, but for a long time before that, that had resulted in him having to seek shelter in a courthouse with his mom. And I think so. And that was not an inappropriate windfall. That was something that
Counsel,
the court.
Let's say we accept that, right? The judge lets him out of jail after being in on that case for a while, a long while, to give him a shot, no pun intended, right? To give him an opportunity to turn his life around. And what happens? Now we have a second victim, and this one is hurt so badly that his spleen had to be surgically removed. There are consequences for actions. And why should we undercut a judge who bent over backwards to work with your client and give this client a chance? Why should we undercut him now and change his sentence by yet another year?
A few things about this, Your Honor, and I just want to emphasize that I think this is critical. So number one, we sort of cite in our briefs, I think, his age, and we cite in our brief there are a lot of people who dedicate their lives to studying, young adult sentencing and young adult crimes. Who there's one view that people under 21 shouldn't be subject to adult jurisdiction at all. There's another view that they shouldn't be subject to mandatory prison sentences at all. And I get that the judge below and this court can't necessarily do that, but I think the court could find something along the lines like, really, when a 19-year-old commits even a B violent felony, even in circumstances like here, and even with the preceding offense that resulted in a YO adjudication, even in that circumstances, because we were bound by the 5 years, even in those circumstances, we're going to give very, very strong consideration to giving him at the very minimum, especially in a circumstance like this, where my client had overcome significant trauma and disadvantage in his life. And despite that, he did have family support. He did have the capacity to live a law-abiding life and turn his life around, as the court below itself found.
Yes, this young man is very lucky. He had a very good judge and a wonderful mother who supports him. You're out of time, sir. Thank you so much. Okay, Miss Nicole Nichols.
Yes, good afternoon, Your Honor. I'm ADA Nicole Neckles for the Office of Dalcel D. Clark. May it please the court. This defendant's sentence was eminently fair. As the court noted, Judge Mogilevsky went above and beyond for this defendant and took into consideration defendant's age and background when he imposed these sentences. The defendant, as the court noted, fired a bullet into a crowded sidewalk and shot a 12-year-old. The bullet lodged in his buttocks and was not able to be removed. This child continues to have a bullet in his buttocks. In addition, nevertheless, the court showed leniency and offered defendant an opportunity and released him on interim probation. 6 months on that probation, defendant engaged in the underlying offense where he, together with others, repeatedly stabbed the victim, resulting in the loss of his spleen. Even then, the court had promised defendant that if he had committed another offense while out, he would get a maximum of 7.5 years. The court did not do that here. The prosecution asked for 15 years on both offenses. The court did not do that. Rather, the court shaved a little off, recognizing defendant's age, and gave him 6.5 years, Your Honor. The defendant, who was by the way, in corrections mittens at both the plea and at sentencing, has already received a windfall sentence. There is nothing here that requires a further reduction to pretty much the minimum sentence that defendant could get. For this offense, the defendant committed while being on probation for another offense, and that offense, an attempted murder in the second degree. We would argue here that this sentence, Your Honor, is eminently fair and should be affirmed by this court. And as to the waiver, we would argue that the plea waiver that was issued here was valid. The court's colloquy appropriately informed the defendant of the appellate rights, that it was separate and distinct from the trial rights. Defendant responded to the court's questioning, expressed he understood the rights he was waiving. He had an opportunity to discuss the waiver with his counsel and gave counsel permission to execute it because defendant, it was admittance and could not execute it himself. And that oral colloquy by itself was sufficient, and it was also affirmed by the written waiver, which further informed the defendant of the appellate rights he was waiving, and that defendant signed and expressed that he understood. For those reasons, we would ask that you affirm.
Thank you so much. Okay, counsels on Madrigal versus Montefiore Medical.
Yep.
Richard Reese
right.
for cross appellant and respondent.
Simons.
I'm sorry, who's for the respondent?
Stephen Bergstein for the respondent.
I thought you were the appellant.
I thought I was too. It was confusion because there's cross appeals going on, and it doesn't matter to me.
Okay. And Mr. Reese, is it?
Yes, Your Honor.
Okay. All right. Well, Mr. Bergenstein, you will go first.
Okay, great.
And you have 5 minutes.
Right. May it please the court. This was a 21-day trial, which, trust me, everybody had a chance to be heard on all these issues. And the jury reached a finding that, based on the evidence, that the plaintiff was the victim of hostile work environment, racial harassment, and the trial court properly found that the evidence supports the verdict in that regard. The record shows extensive anti-Hispanic name-calling and verbal abuse directed at the plaintiff from two of her supervisors, Sitar and Ramos. Her co-workers corroborated some of that harassment, but a good deal of the evidence was through the plaintiff's sworn testimony, which the jury is allowed to credit. And, any argument that the plaintiff is not credible, it didn't happen, she was previously friends with Sitar, that's all credibility for the jury. And the trial court got it right. There's enough evidence here to support a finding under the city law that plaintiff was treated less well because of her national origin. We have a verdict also in plaintiff's favor on retaliation.
Did you enter a judgment in this case?
Did somebody enter a judgment in this case?
Yes.
I don't know.
Well, what are you appealing?
I'm appealing the trial court's rulings that.
What is the appealable order that you have? What is your appealable order?
The appealable order is the trial court's decision dated December 12th, 2019 rather, that resolved all post-trial motions.
But that didn't also deal with the court's ruling, did it? And the sexual harassment, which was during the trial, not at the post-trial. Was that brought up again in this December decision?
No, the parties did not brief the issue post-trial about punitive damages or the sexual harassment.
So I think that's what Judge Mazzarelli was saying. If that wasn't dealt with in the December 2019 post-trial order, and there was no final judgment ever issued, what's the appealable order? I mean, this was something that happened on the record during the trial.
Correct.
We have to have jurisdiction over things through an appealable order.
Correct. The only answer I can give you is the trial court issued a ruling December 12th that terminated all proceedings in the case, and the orders he issued at trial, we preserved our objection to those orders when and there's no waiver involved. We don't have to raise issues in the post-trial motion surrounding punitive damages and the sexual harassment claim. There is evidence in support of the retaliation claim. The plaintiff filed a lawsuit under the city law while she was still employed there. 3 or 4 months later, she was terminated. The claim was that she had lied about objecting to sexual harassment and the battery, but the jury had a factual basis to find that the sexual harassment complaint raised by the plaintiff in the course of her employment was made in good faith, and that she also complained about the battery in good faith. And one way that we know that she complained about the battery in good faith is that the jury did find that Ramos had attacked her with a telephone in the course of her employment. There really is no way to argue as a matter of law that the sexual harassment complaint made by plaintiff and the battery objection in the course of her employment was made in bad faith. She testified to both incidents under oath. There was some degree of corroboration. With respect to the battery, the plaintiff went to the ER right away. Her son and her father corroborated her testimony. Her son saw a thumbprint on her arm, reflecting a swelling and redness on her face. Her husband also saw a big mark on her arm, quote, where someone grabbed you with force. She took a couple of months off, disability leave right after this episode. These were good faith complaints. The jury was entitled to find that the plaintiff's termination was in retaliation for these complaints about her complaints about national origin discrimination in her state court lawsuit.
Counsel. It's Justice Moulton. Can you speak to the reduction of compensatory damages by the judge?
Yeah, the trial court substantially reduces the compensatory damages. The argument is that the plaintiff's pain and suffering was substantial and was in excess of the $250,000 for the racial harassments and the $150,000 for the termination. The discrimination changed her life. The plaintiff's family testified that she was never the same after these experiences. She went on medication, anti-anxiety, anti-depression medication. She had panic attacks. She went to the emergency room as a consequence of some of these episodes. And I think her son and her husband testified that her emotional state in this regard lasted several years. So this is a lifestyle change, not simply significant pain and suffering. This is more than significant pain and suffering. And the jury was able to find that this was at least a 7-figure case relating to the harassment, we cited some cases in our brief where the Second Circuit Court of Appeals has upheld 7-figure racial harassment verdicts when you have extensive racial harassment. We can analogize that case to this case for the reasons that I've already discussed and that we mentioned in our briefs. So the district court took away the battery verdict. The jury ruled in the plaintiff's favor in that regard. There was an evidentiary basis to support the verdict in favor of battery. She claims her supervisor hit her with a phone. We can argue about how much those damages are worth, but again, she went to the ER. But I don't think you can say that there's no evidence to support the battery claim. She explained that Ramos, the supervisor, had a.
Okay, you are repeating yourself now. Is there any other additional argument you want to make, or I will go to your respondent?
No, I think that does it, Your Honor.
Thank you so much. Mr. Reese? You have to unmute your mic.
That's a good first step.
Yes, it's happened to me.
Yeah.
Well, may it please the court. My name is Richard Reese. I am appearing for Montefiore Medical Center and the individual defendants in this case. And my understanding is that there are 3 issues on appeal. One is whether or not the trial court improperly, from plaintiff's point of view, improperly dismissed the battery claim against defendant Ramos. And the other issues on appeal, which we are bringing, is whether or not there was sufficient evidence to find retaliation and sufficient evidence to find that there was, in fact, a hostile work environment impacting Ms. Madrigal's place of employment. I think it's important to focus on 4 issues, and I'd like to run through those with Your Honor's indulgence. The first is context.
Is there any question that clearly her complaints about being spoken to with complete disrespect and with ethnic slurs that were corroborated by coworkers, why is that not sufficient to create a hostile work environment?
Well, there are several comebacks to that. First, they were all fully investigated. First of all, let's be clear. When she was an employee at Montefiore and at Montefiore, she never complained about any sort of national origin discrimination at all.
She said she was called a fat Mexican pig.
She says that after she was in her complaint many years later. The fact is, Your Honor, that
and the jury heard it, and the jury believed it, right?
But the fact is,
so why should we overturn the jury determination here?
Because the jury's determination doesn't exist in a vacuum. It comes within the record holistically. The fact is, her complaints against her supervisors were completely investigated by Montefiore. They are.
So sir, you say that, but that's why we have a trial, right? The fact that an employer, let me finish, I'm talking. The fact that an employer does an internal investigation and determines this is unfounded. You're saying that ends the story and a person doesn't have a right to seek recourse through the courts?
I'm saying that those remarks, as a matter of law, are stray remarks that had no impact on plaintiff's work environment.
Not if they happened over years, like she said.
But, Your Honor, she can say—
This wasn't a singular event, sir.
Your Honor, they were separated by months and, in fact, by years. And in
so
fact,
being called a Mexican pig every couple of months is okay?
So she says, Your Honor, and I only have to—
Well, I'm asking you, if that is true, is that okay?
It is actionable if it changes her work environment to be, if those remarks are severe and pervasive and creates a hostile work environment. And in this case, I posit to you—
You have to take the position that even one of those remarks is wrong to be said. Absolutely.
Wrong is a different story.
There's no place in the workplace for that kind of language and that kind of discourse.
If it happens, you are absolutely correct.
And the jury said it did happen. So we go back to that.
Right, and she's entitled to say that, and the defense is entitled
No,
to take
I'm saying the jury determined that it happened.
And I'm
12
telling
people listen, no, 6 people listened to this evidence. I was mixing up my courts, having done both, forgive me. 6 jurors listened to the evidence, found her more credible than your witnesses. And why should the court then just disregard the jury's verdict?
because appellate courts disregard jury verdicts all the time.
The
because
appellate
jury-
court hasn't done that yet, so you're
Well,
jumping ahead of yourself.
Not in this case. But in fact, juries do make mistakes. I make mistakes. Judges make mistakes. And I think it's
Never.
important to understand I think it's important, not you, Judge. I think it's important to understand the context of this case and understand this plaintiff. This is a plaintiff who accused now remember, she's a member of 1199. She was represented by a union throughout her whole employment. This is a plaintiff who accused her coworker, a fellow 1199 member, a fellow someone who was of Puerto Rican national origin, and she accused him of hitting her over the head for 1 minute with a telephone. And in fact, that is an allegation that put his employment at risk, that in fact put his liberty at risk. And in fact, that was simply not true. And the trial court found that this enormous either misperception of reality or a lie, that it was a lie. And he says her testimony is entirely inconsistent with the record. And so what happened in that case? The fact is that she went to the ER. They found no evidence of injury. There was a witness 3 feet away. She didn't hear or see anything. It was denied by the accused, defendant Ramos. The defendant's union didn't believe her. She wanted to appeal her. She was suspended for a day. She wanted to take her suspension to arbitration. Local 1199, a very powerful union in New York, refused to take her case.
But
She
Mr.
appealed
Reese,
that.
Mr. Reese, we read that and I understand that. But the jury, I don't know if you tried the case, but the jury heard all this testimony, and I'm sure that there was significant cross-examination of both the plaintiff and Mr. Ramos and any of the other witnesses that were put on by either side. And the jury came down, made this finding. Judge Sherman didn't agree based on his interpretation, but in fact, 6 jurors sit and listen to a whole trial, and this is where they came down to. So a lot of times we know that trials are he says, she says, she says, she says, and somebody has to make a determination, and that's what happened here.
Right, but I think
yes, there was testimony that there was some testimony that might have, some people didn't see anything, but maybe it was under the hairline. I mean, there are a lot of different questions, but I think the jury heard all that. So why should we, after it was aired out, direct examination, cross-examination, what we do in a trial, why should we go another way at this stage?
Because juries do make mistakes, and because as a matter of law, there are things that happen in the workplace on an individual basis may seem offensive, but they don't rise to be a violation of law. Judge Sherman's decision.
Not that they seem offensive, sir.
If
someone is called a Mexican pig,
Your Honor,
that is offensive.
And I'm not going to accept that. I agree with you, but I don't accept that happened in this case.
I mean, we have to be careful how we argue this, lest anyone think, that is appropriate. It is not appropriate.
It is
and
not.
And whether it rises to the level of being compensable is what we are going to determine.
Exactly, Your Honor. And I agree with you. On every level, it is inappropriate, if it happened. But I posit to you, in the context of this case, right? These are not strangers. Ms. Madrigal joined Montefiore in 1992. The woman the supervisor that she is alleging, engaged in this hostile conduct. They worked together since 1992 until 2011. They were friends. They went on lunch breaks. Plaintiff was offered a promotion by this supervisor that she alleges is hostile to her.
We keep arguing credibility. I mean, that's a great argument if we were a jury, but we're not a jury. So you want to talk about the reduction of compensatory damages for a minute?
Sure. I mean, I think the reduction should be 0, and I think the court was right because the fact is that Ms. Madrigal did not suffer severe emotional distress. She went to one doctor who was not a psychiatrist. He gave her a prescription.
Counsel, we're going to give you one more chance to answer the question, what you'd like us to consider on a reduction, because a reduction to 0 would be unlawful. If there is a plaintiff's verdict, that verdict must come with a number. So unless you'd like us to substitute a number for you, you might want to answer that question.
So my answer to that question would be $500. The plaintiff, in fact, was given a prescription for a sleeping pill. She never took them. She never saw any therapist. There is no outside evidence at all that she was emotionally distressed. She worked her night job. She worked a second job all the time while working at Montefiore. She never missed a day's work. She continued to work after Montefiore. She never missed a day's work. And in fact, she made more money after she left Montefiore at her second job than when she worked at
We know that the record is clear. She's not a malingerer.
She's not a malingerer. In fact, she's a very hardworking person who has some very unfortunate perceptions about what happened to her in the workplace.
Or she had some terrible things happen to her in the workplace.
Well, but Your Honor, you have to look at this record.
Counsel, we don't have to argue it. I don't have to debate it with you. That's my comment, and it is what it is. Do you have any other arguments you wish to make?
Not at this time.
Thank you so much, sir, to the both of you. You didn't reserve any rebuttal time. Thank you. The case of Board of Managers versus New York City Department of Finance. Mr. Gartner.
Yes, Your Honor, I would request from the court if I could reserve 2 minutes for rebuttal.
Okay, so you have 5 on your main argument. You may proceed.
Okay, this is a case where the Department of Finance corrected an error. They had been taxing a condominium for 43,000 square feet that didn't actually exist. This had gone on for 31 years. It is only for 6 years that they're seeking refunds because that's all that's permitted under the regulatory statute of limitations. The Department of Finance, while agreeing that they were going to correct the error, said you get nothing back, and you get nothing back because A, we find that the impact was de minimis, or B, we found new comparables that would support the value that we had put on the property previously. And our position is that, first of all, we've shown that the amount would be $4.125 million over 6 years, or approximately $14,000 per condominium unit for 294 condominium units, that's not de minimis under anyone's view. And that second of all—
Mr. Gartner, can I ask you a question? Was one of the things that the city said that the footage that they made a mistake on, and obviously they made a mistake, it was not in the individual's condominiums, but it was in the common area, so it may not have affected the taxes, whatever, that were paid by the individual unit owners? Is that part of their argument?
Well, they're not talking about the common areas, but what they were saying, at least below, was that they use net square footage rather than gross square footage, and that gross square footage wouldn't have an impact. They don't argue that.
It wasn't specifically in the units. It was outside of the individual units. Wasn't that true? It might have been like in between the walls or things like that, in the hallways. What we demonstrated was that the formula that the city uses, and which it publishes, and which it explains on the notices to tenants when the taxes are charged, is that they use the gross square footage of all the residential areas in order to determine the value of the building, and then they break it down into the percentage that each of the condominium units makes up of the whole, which is basically comes from the declaration, the condominium declaration, so that, there's no question. And again, this isn't challenged in the briefs in this court. It was, it was raised below, but that argument was foregone in this court.
And the other question was, can they now go back and say, oh, we're finding new comparables because actually we had underassessed the property relative to the number of feet. So now we're going to go get more expensive comparables. So that will support retroactively. And what we've shown is that that's prohibited by the administrative finality doctrine. It's prohibited by 11-206. And, that it's something that, and what we've shown as a matter of fact is that the city has aggressively argued that if they went back and found an error, which actually called for increased taxes to be paid now, that because no tax cert action had been brought years ago, you'd be barred from contesting it. You'd have to pay the additional tax at this point if they found an error and corrected it to your disadvantage. And the same should really be true here.
Thank you.
Thank you.
Thank you.
Okay.
Good afternoon, Your Honor.
Wallish?
Yes, can you hear me?
Yes, I can. We can't
Great.
see you, but we can hear you.
I can see her.
I can
Oh,
see
I
it.
can't
I
yet.
can see her.
Okay.
You can continue.
Thank you, Your Honor. Your Honor, appellant would have you believe that this is a case about arithmetic, about plugging numbers mechanically into a formula. Well, what this case is actually about is the discretion afforded the Department of Finance when evaluating clerical errors. Administrative Code 11-206 states that the Commissioner of Finance may correct any assessment or tax which is erroneous due to a clerical error. Moreover, this concept of the Department of Finance's discretion was recognized by a court in a better world. Your Honors, the Department of Finance is an expert at assessing properties, as it values over 1 million properties each year. When a clerical error is presented to the Department of Finance through Administrative Code 11-206, the Department of Finance must have the discretion, utilizing its expertise and its judgment, to determine what effect, if any, the clerical error correction had on the value of the property. Your Honors, in this case, we have a clerical error correction that does not impact value. It is an error without significance or without weight. Specifically, the Department of Finance reviewed petitioner's submissions and agreed to adjust the gross square footage of the property based on the evidence presented. However, once correcting the gross square footage, the Department of Finance reviewed its valuation analysis and found that the original assessed value for the subject property was appropriate.
Well, doesn't that seem a little arbitrary and capricious? I mean, now it has a lot less square footage, but they don't get any benefit, and then you go and find a different comparables to sort of base that up. I'm sure if it happened the other way, they wouldn't be getting any benefit from it. So it seems a little arbitrary.
Well, Your Honor, we're talking about an 8% difference in gross square footage. As has been discussed, there were other factors that the Department of Finance knew that are not challenged. For instance, the net square footage, the location of the property, etc. And what the
challenge the location, but okay.
we could have an error as to where it is. I suppose that's what we're arguing is that any time one factor is changed in the valuation analysis, our expert assessors have to be able to go back and review the entire analysis to make sure that it still makes sense, because changing one factor could lead to a change in the rest of the valuation analysis. And in terms of arbitrary or capricious, a lower court did review the evidence in the record and found that the Department of Finance that the Department of Finance's decision was rational and was not arbitrary and capricious, that there was enough evidence in the record to support it. Speaking of the discretion of the administrative agency, the lower court also recognized that where a court examines an administrative action involving the exercise of discretion, That's sorry, I thought I had a question. And where it involves, in this case, the factual evaluations that are within the agency's expertise, that the deference has to be afforded to the agency. I'd like to speak a minute about the doctrine of administrative finality. This concept, the doctrine of administrative finality, has never been applied in this context with respect to a clerical error pursuant to Administrative Code 11-206. What we argue is that 11-206, by its very nature, thwarts the administrative finality of the final assessment tax roll, because it opens it back up. The tax roll is supposed to be final every year, but through correcting clerical error, it's disturbing that finality. As I mentioned before, all we're saying is that once that finality has been disturbed and one factor has been changed, the Department of Finances cannot have its hands tied by just looking at one factor and then not being able to see how that factor impacts the entire analysis. And so that the only recourse in this situation that makes sense to make sure the final assessed value is appropriate is if the Department of Finance looks at all the factors once an initial factor such as gross square footage has changed, and to see if the actual valuation, the actual assessed value is still appropriate. Your Honors, in addition, I would like to note that the petitioner had the opportunity to challenge this assessment every year for these 31 years if the petitioner felt that the property was overassessed through the normal process of filing Article 7 petition.
But wait, it was the miscalculation that caused the petition, no?
Your Honor, I'm speaking about the regular process by which Article 7, which a petitioner would normally file its taxes through filing Article 7 petition and going through the process of having presenting evidence that its assessment is overvalued in a de novo review. That's what would typically happen each year.
Except you're blaming them for not challenging it over the 31 years, but it wasn't until most recently that the Department of Finance made the correction. So prior to that, what would the purpose of that have been?
Well, Your Honor,
I mean, certainly not based on the arguments being presented here. The argument here is you miscalculated my space, and therefore I should get credit for that overcalculation. It's pretty simple.
But Your Honor, every year the Department of Finance sends a notice of property value to the petitioner, which lists the gross square footage. So the petitioner had 31 years of this notice of property value, and if there was an error in the gross square footage, they could have alerted the Department of Finance to that error. In regards to the gross square footage and its effect, what we're arguing is that it did not have a significant effect on value. That
why do you say that?
For several reasons. First, we had a lot of factors that we knew that were correct, such as the net square footage, the number of apartments, the location, the type of building,
But as Judge Kapnick, because you're out of time, as Judge Kapnick alluded to earlier, here the miscalculation was not in the individual units, which would directly affect each unit owner's value, right? But was rather the common areas. Is that correct?
The gross square footage, meaning the entire unit, as opposed to the net square footage of the entire building, which is the net square footage that was the individual units. That's correct, Your Honor. Your Honor, if I can conclude, the lower court recognized that the discretion afforded to the Department of Finance through Administrative Code 11-206 and found that the Department of Finance's determination regarding the original assessed value was rational and reasonable, neither arbitrary and capricious, And the city asks that the lower court's decision be affirmed by this court.
Thank you. Mr. Gardner, you have 2 minutes.
Right. I was going to say that that again, we demonstrated at length in the brief the formula that the city publishes and gives notice of to the taxpayers regarding how the taxes are calculated, and that's not disputed in this court by the city. And section 11-206 says that if the taxes compute, and whatever their discretion is in correcting a clerical error, it's not of concern because they did correct it, in fact. So that's not an issue. And 11-206 says if the taxes computed on such erroneous assessment have been paid, the Commissioner of Finance is authorized to refund or credit the difference between the taxes computed on the erroneous and corrected assessments. It is an arithmetic issue. And
right, but the language you just cited said they are authorized. It didn't say they are mandated.
But it also doesn't say that they're authorized to do anything different if they've in fact corrected an error. In other words, the idea that they can now go back and redo the original assessment process when there is no longer an Article 7, the tax certiorari remedy would leave the taxpayers completely without a remedy. And as the court noted in the Better World case, basically leave 11-206, the correction, the clerical correction statute without meaning.
Thank you so much.
Thank you.
Have a good day.
Thank you.
Glissetti versus MTA, Ms. has help me.
It's okay. I've been called worse.
But tell me how to pronounce it.
Hasapitas.
Hasapitas.
See, not so bad once you hear it, right?
Thank you, Hasapitas.
May I reserve 1 minute for rebuttal, please?
Sure, you may.
Thank you.
You may proceed.
Thank you. May it please the court, I'm Annette Hasapitas representing the petitioner. In this case, the court and the Board of Managers respectfully erred in denying my client an accidental disability benefits.
Ms. Hasapitas, you are very experienced in this area, and you know as well as we know that the definition that is employed for the word accident is a very difficult one for your client to satisfy.
I do, Your Honor. I do. And actually, I'm sorry.
That's okay. And I was just going to say, and the standard that you must meet for us to reverse a finding of the trial court is also a very difficult one for your client to meet.
It is a heavier burden, to be sure. Now, I will address your point first. Frankly, I'm not surprised that I got this question, and I did inform my client the state of the case law with respect to these issues. And in doing so, I said to myself, let me see and verify whether or not my instincts about the body of case law really matches up with the case law. So, for example, 2020, the three of the appellate divisions ruled on 11 ADR appeals. All of them were affirming dismissals. I had to dig really deep and probably found a half a dozen cases dating back to 2010, where there was a determination of an accident was made by an appellate court. And I would submit to you that the issue is not really a definition of accident as much as it is the way foreseeability is being defined and applied to the facts. Because when you consider the events have to occur during the performance of routine duties. Well, theoretically, if you are injured while performing routine duties, almost everything could be considered foreseeable if you apply the rule that broadly. And so it's really a matter of how far do we go with this? And I informed Mr. Preston before the argument that I was going to reference a case where Judge Manzanet, you had the distinction of being the lone dissenter on the case, and it was Pastelov. And in Pastelov, your language there really highlighted the issue. In Pastelov, and I'm just going to summarize it very briefly, I know I have very little time. In Pastelov, an officer was injured. He was at a fire scene. He tripped over a charged fire hose, and the majority said
that appeal was withdrawn.
There's a decision on it. There is a decision on it. 120.
No, I mean to the Court of Appeals, the lead.
Oh, okay. Okay. Well, let's hope that this isn't one that's going there. But anyway, so you, Judge Manzanet, you dissented, and among other things, you cited one of the cases that I cited in the brief that I submit is on all fours with this case. It's Flannelly. But you said the fact that a police officer may have familiarity with fire scenes generally or has responded to fire scenes in the past is not the equivalent of familiarity or knowledge of a particular fire scene to render the placement of or movement of objects to be unexpected. Each fire scene is different and none are stationary or controlled. And I'd submit to you that that is really the way we should view foreseeability issues. That is why Flannelly was properly decided. Now, that's a 2000 case, and I don't know if the court knows my briefs. I usually come up with the most current cases, but Flannelly was it, and that was 2000, okay? And in Flannelly, the incident, the events were deemed an accident because the wires for TV and VCR had been unexpectedly moved, and the officer tripped over them. Now, in this case, the precipitating cause and what was not foreseeable was that when my client when she unlocked the gate, she did not expect that the lock would fall to the ground. Again, I know I really appreciate the court's time. I'm just going to reiterate the very brief sequence of facts.
Well, but wasn't the lock also on the opposite side?
Correct.
Which is what caused, in all likelihood, what caused her to drop the lock in the first place.
Correct. What the testimony was that when she went on her patrol, performing her routine duties, she always had seen either one lock on the outside or two locks. And all it took was for her to unlock the lock on the outside, remove the chains, and she'd still be able to hold that gate and open the gate in a controlled manner rather than having gravity swing forward. In this singular event, over the 20 years of her career, there was one lock and it was on the inside. As a result of that, she was forced to reach over the gate. She tried to reach through, she had to reach over. And when she did so, the lock unexpectedly dropped to the ground. That had not happened before. It was not the gate swinging, it was the lock dropping, which prevented her from being able to remove her arm in time. In previous instances, she was able to unlock the lock, remove the chains while holding the gate, and it was a controlled open. So I would submit to you that the facts and really the sort of the rule or the analysis of Judge Manzanet in the dissenting opinion of Pastelov necessitates, in this case, a modification of the lower court's determination. I thank you.
Thank you. Mr. Preston.
Good afternoon.
Good afternoon.
May it please the court, my name is Andrew Preston. I'm appearing for respondents. Initially, I want to distinguish Pastelov, the holding in that case, which is actually favorable to our position. The fact pattern in that case, though, involves the police officer tripping over a fire hose at a, quote, chaotic rescue scene.
It was a chaotic rescue scene. I wrote extensively on that case, counsel. So I suggest you take your 2 minutes and argue this case, because you're not going to convince me that that was not a chaotic scene.
I'm saying merely, Your Honor, that that's very different from the facts that give rise to this incident. There was no chaos in this scene. The appellant knew the scene. She knew the gate. She knew the lock. She had been there many times. She knew it would swing open.
But you do admit that it wasn't in its normal condition. Typically, that lock was on the outside, which would not have her put her hand through the gate, right?
Yes.
And it was that action and the falling of the lock, which was not placed properly, something she had never encountered before, right?
Absolutely.
So it wasn't familiar in that respect.
Well, I disagree on that point. The Board of Managers agreed with the MTA's medical board and found that quote, simple gravity and common sense would dictate that the gates open when the locks and chain are removed. That's at page 1170 of the record. So this officer failed to use common sense by reaching over when she knew very well that the gate could open.
How else is she supposed to do her job?
I'm sorry, I couldn't hear that.
The lock was on the opposite side. Her duty was to look at that area, right? So how was she supposed to do her job?
There's nothing in the record that suggests an alternate method for her to do that, nor did she so state. I would argue that if she can't do something safely with common sense in a non-emergency situation, she shouldn't do it, and she should find another way to do it.
Counsel, I appreciate that you have a position you have to take. I am always at a loss why one thinks that the best argument is to insult the people you're arguing against. Now she has no common sense because she was so committed to her job that she attempted to do it even though someone stupidly left the lock on the wrong side.
This officer's received disability benefits. It's just not accidental disability benefits, and she's challenging the board's decision on that.
Which are less, right?
Yes, they are.
Well, I mean, so we some of us can't poo-poo the fact that a couple of extra dollars in our pocket will make our family situation and our lives a better existence, especially on retirement.
And I just wanted to say that in this particular case, and this doesn't happen a lot, the hearing officer who actually heard the testimony did find that the incident was an accident. Ultimately, the board did not agree with the hearing officer, but it's not like it's a ridiculous position to take because the person that heard it did make that finding.
I agree. The board of managers agreed with the pension board and not the recommendation of the hearing officer. Right. But again, the question for this court is not whether it's ridiculous or not. It's whether there was a rational basis for the decision below.
That's right. You're right. Anything else?
No, not unless there's any questions.
Any questions? Thank you so much. You reserved a minute.
I did. Thank you. I would submit to you that the fact that my client received performance of duty disability benefits does not mitigate her entitlement to pursue the appeal or in any way diffuse her position with respect to the law on these issues. With respect to whether or not this was common sense, I would submit to the court that if my client had fractured her hand and ended her career because of a fractured dominant hand, because she had failed to hold the gate and the locks were where they were supposed to be.
She was trying to do her job, wasn't she?
She was. She was doing her job, and she testified that she attempted to open the gates because she was suspicious that this was not locked properly and that perhaps someone had engaged in criminal conduct on the premises. So she wanted to check the site, to check the yard, to make sure that it was clear. And again, she retired out 2 years after the fact. She had hand surgery. She had immediately hand in her guns. She could no longer use a firearm. That's why she received the initial benefits. But clearly, and again, Judge Mazzarelli, you started by pointing out how difficult these cases are. I'd submit to you that this is one of those cases where it was an unforeseeable accident. The precipitating cause was the lock falling in an uncontrolled manner, which had never occurred before. It was not the swinging gate, and I thank the court for its time and attention.
Thank you so much. And last but not least, MBF Clearing versus JP Morgan. Mr. Goldberg, you have 7-2. You may proceed.
Good afternoon. May it please the court. The appellants submit that the motion court erroneously declined to review the substantive merits of the third amended complaint, and instead they improperly implied the law of the case doctrine. In addition, the motion court erroneously held that the plaintiff's proper remedy would have been to pursue an appeal of the dismissal of the second amended complaint. A little, not detailed history, but brief history is necessary here. When the second amended complaint was dismissed, it was dismissed without prejudice. However, no leave to file an amended complaint was granted. Instead, plaintiffs were required to file a motion for leave to amend. Plaintiffs filed that motion for leave to amend, and it was originally denied in a one-sentence order, deeming that it was moot. Plaintiffs then filed a motion to re-argue.
Counsel, this Justice Moulton, we're pretty familiar with the procedural history. And also, as an appellate court, we know we're not bound by law of the case doctrine. So why don't we get to the merits? Particularly, you've got a problem with reasonable reliance, and I would focus on that.
Okay, Your Honor. The issue of justifiable reliance, the respondents argue because of the banking and customer relationship that plaintiffs cannot argue justifiable reliance. However, this case is unique because it involves the commodities laws. Right? J.P. Morgan, the respondent, made a determination to become what's known as a custodian and settlement bank. Once they became a custodian settlement bank, they were governed by a separate set of rules. They applied to become this. They applied to be able to handle margin money, to handle customer segregated accounts. The rules that then applied were completely different than a banking relationship. A bank that is not a custodian and settlement bank cannot do the things that J.P. Morgan is now able to do by applying and being approved to be a custodian and settlement bank. Right? The agreement between the parties, right? There's two issues that are demonstrated here. There's both a fiduciary relationship and a unique expertise relationship. By becoming a custodian, segregation, and settlement bank, they had an expertise in the handling and maintaining customer segregated funds. In addition, the agreement between the parties—
But your clients also have expertise in the commodities market, being registered with CEA.
That's
right?
correct. That's correct. But although they have the same knowledge of the rules and the law, the issue here are the representations made by the respondents to the plaintiffs. And those were factual representations. I'd like to just finish one issue on the reasonable reliance issue, because I know it's critical, and then I'll get to the issue regarding my client's background as well. The agreement between the parties that sets the standard, which is located in the record under 487, it's called a Commodity Customer Segregated Bank Account Statement. In the first paragraph, it even states that the trust department of the bank will establish and maintain the accounts. That creates the fiduciary relationship.
Well, wait, how does that create a fiduciary? I mean, shouldn't there have, I guess maybe I'm thinking about it as a special relationship. I mean, they had a bank, a relationship between, a customer and a bank. And why would they have any more responsibility, even if they're taking care? I mean, isn't it just a regular relationship that a bank and a depositor would have in any kind of, these things? I mean, they don't have that much, they don't have a higher responsibility to your clients.
Well, they actually do, Your Honor, because the uniqueness of the Commodities Exchange Act, and I need to give a little background, is unlike a bank depositor relationship where there's an FDIC insurance, or in the securities business where it's known as SIPC to protect it, there's no protection to a customer's funds in the commodities industry unless it's held in what is known as a segregated account. If it's held in a segregated account, it affords the protections to the ultimate customer of the funds in the event of bankruptcy by either the underlying bank or the FCM, which is my client. That creates the uniqueness of the relationship. It's governed by a different set of laws. It's not governed by banking laws. It's governed by the Commodities Exchange Act, right? And the
problem you have here is that while admittedly J.P. Morgan did not verbally advise you of the change of the name of the account, deleting the segregated language, the statements that were sent to your client did reveal the change. And isn't your client responsible for having reviewed those statements?
Two responses to that. First, the change in any account statement that would be sent would not be received for 30 plus days, right? So the change that took place to the account would have occurred on day one. On day one would have been the violation. Okay, so even if statements are sent, as you know, they're not received until some period of time at the end of after the close of the end of the month.
But they didn't even determine it then, did they?
No.
I mean, unfortunately, they didn't see it for many, many months down the road.
Well, Your Honor, it skips to me what I think is a very critical question. What we're saying here is that the bank has the authority to change the ownership in an account without any prior notice or authorization from a customer. That the best examples I could give you, Your Honor, and it has legal effect. The best examples I can give you is if you establish an IOLA account as an attorney, and you believe you have an IOLA account, and you have money in the IOLA account. Somehow the bank changes it so it's no longer an IOLA account. You're in violation of a rule, and you're in violation of the rule as soon as they make the change. Banks cannot arbitrarily, make a change to an account, change the ownership to the account, and then put the onus upon the customer, who can't find out for a minimum of 40 days, right? And say it's the customer's fault. That would allow anyone to commit fraud at any time and put the burden completely on the party that's getting defrauded.
Counsel, when you opened the account in question, which I guess is 2069,
Yes.
was it the application, did it say it would be a segregated account or not?
The application linked it to the account. It was a sub-account and linked it to the master account, which was, I believe, 0253, which was the segregated account. And then when the inquiries were made regarding the setup of the account, the 2069 account, the first monthly statement, as indicated in the papers, not only had the correct title, it had the same spelling error that was in the master account. Right? That was one thing that was given to the clients. And the second was there was communication between the parties regarding the seg letter. So at that point, my clients had done everything that was required of it under the Commodities Exchange Act, under Rule 1.20 and 1.26, which is to ensure the proper title, which was the representation made by the bank. This is what they asked. It's a factual representation, not an opinion of law. And for the segregation letter to apply. Okay, so they've done the two things that were necessary. So when the account was set up, plaintiff could reasonably believe that they had a segregated account, which, as we know, at the end of the day, turned out to be false.
Okay, you'll have 2 minutes on rebuttal.
Thank you.
Okay. All right. Mr. Picone?
Yes, good afternoon, Your Honors.
Good afternoon. You have 7 minutes.
Thank you. May it please the court, David Pecan, Proskauer Rose, for the respondents. Judge Moulton started by raising the reasonable reliance issue, so let me jump right to that because I do think that goes to the heart of the sufficiency of the claims. Your Honor, there are at least 3 reasons why reasonable reliance cannot be established as a matter of law. The first is the CFTC regulations that apply specifically to MBF, the appellant. Among other things, there's Regulation 166.3, which required the appellant, MBF, to supervise its officers, its employees, its agents, and other persons who are acting in a similar function. It's clear that the responsibility under the regulations is put on MBF, and it cannot simply say it blindly relied on purported representations as to whether the accounts met the requirements for a segregated account. The second issue goes to one of the things that Mr. Goldberg mentioned, which is the claim that MBF has made that the 2069 account was purportedly represented to it to be a sub-account of the 253 account. I would direct the court to the record at page 487 through 491. And on page 487, paragraph 1, it makes clear that there aren't sub-accounts of the 253 account, but there could be separate accounts that would be governed by the same terms as the 253 account. But paragraph 1 makes clear that there are 2 requirements for that to happen. Those requirements is MBF had to request in writing of JP Morgan to have that account, 2069, be governed by the terms of 253. In addition, under paragraph 1, the Schedule 1 to this agreement had to be modified to reflect that the 2069 account was in fact being governed by the 253 account. There is no allegation in the TAC that any such written request was made, and the CFTC complaint, which is incorporated into the third amended complaint, expressly states
but
that
I thought that at the at the opening of this account, that plaintiffs made clear what the purpose of the account was, so that this wasn't a surprise why this particular account was being set up, and why I don't understand, and quite frankly was disturbed that the bank would just alter the title of an account of a account holder without notifying them in writing that that change was happening to their account, and why?
Your Honor, if I can, I'd like to address that. First, the request was made to change the linking of the 2069 account to a different account. Whether or not that was the underlying reason for the change in titling, the record doesn't make clear. But in fact, the way these things are communicated with depositors, but particularly a sophisticated party, is through the account statements that are sent on a monthly basis.
So you're saying it's okay for any bank to just change the label of an account without regard for why the account was set up in a particular way, without notice to the account holder, not this gotcha. I hope you're reading your statement so you see what I did. I mean, that's not the way banks should work.
And it's not, Your Honor. Obviously, we have to deal with the allegations as they are. But in fact, here, because MBF is a regulated entity, it had the obligation to review its account statements.
That's all well and fine. The point is, don't you have an obligation to notify your account holders of changes to their account? Period.
And they were notified of that change.
How? By the statement?
By virtue, at least based on the record here, they were notified by virtue of the account statements that were sent. I am sure if we get into the facts someday, and we hope we don't, obviously, you'll see that they received other notices.
But I also, I mean, sort of to follow up on Judge Manzanet's question, I mean, you're saying that the plaintiff was sophisticated and they knew how they had to hold their account assets in specifically designated types of accounts. But you knew that too. So by switching this to a different kind of an account, like you knew you're putting your client or your customer, I guess, or your customer in a position to potentially have what happened here, an audit, and then get a very severe fine because they weren't holding their accounts right. So I guess I just piggyback onto what Judge Manzanet asked. I mean, how do you come to go and change not the name of the account, but the way the account is held, which is such an important aspect under these rules and regulations that you quoted at the beginning of your argument?
Your Honor, just to direct the question here, the problem here, according to the CFTC, was not the title of the account. That's not why the CFTC found that there was a violation of the rules. What the CFT said in its complaint was that there was no seg letter for the account. In fact, if you look at the
CFT, weren't you supposed? I mean, there was a seg letter for the other account, so you didn't have any obligation to say, "Oh, you need a seg letter for this sub account or whatever it was, new account."
We wouldn't have had any obligation. In fact, that's what the regulations do. They impose the duty on the regulated party, MBF, to provide to make a determination for itself whether it has the requisite seg letter. So it was always the responsibility. In fairness, I believe the change of account title is irrelevant in light of the CFTC's allegations that there wasn't a violation because of the change in the name in March 2009. There was a violation because at the very outset of the opening of this account, there was not a seg letter, and at no point during the lifetime of the account was there a seg letter. So as a result, with respect, I think while the account statement's names changed, it doesn't have any effect upon why the CFTC brought a claim against MBF. In fact, if you
So are you saying that had they had the seg letter and your bank changes the classification of this account, this plaintiff would not be in this situation?
If the plaintiff had a seg letter for this account and JP Morgan had changed the title, right, not at the request of the plaintiff, but had changed the title in a way and then not disclosed it, there would potentially be some basis for a claim. But the reason why in this case it wouldn't, with an ordinary depositor, I would agree with you, Your Honor. But here, because we have the regulations, it is an overlay over the responsibilities of the particular appellant. This appellant had to review its regulations. It had to make a determination for itself whether it was reviewing the title, because that is one of the criteria for having a segregated account. What they can't say is we didn't look at our account statements because all we wanted to look at was the balance, not this plaintiff.
Thank you so much. You have 2 minutes, Mr. Goldberg, and unmute yourself so we can hear you.
Thank you. Your Honor, the third amended complaint is crystal clear that with respect to the seg letter, it reached out to the plaintiff, to the defendant multiple times to ensure that the seg letter that was in existence covered the new account because it was a sub account. There's no, you have to take the complaint as true, but there's no law that says one seg letter cannot cover multiple accounts. So even though the plaintiff is a sophisticated investor, they are still allowed to reasonably rely on the factual representations of the custodian and settlement bank that said that the seg letter can apply. It wasn't until the CFTC in 2010 said provided, and it's in the complaint, and the plaintiff reached out and said, provide the information that you told us we had. And they then, for the first time, reached back and said, no, this was never a segregated account. Never a segregated account almost 2 years later. The allegations are detailed that on each step of the way, there's 12 factual sections in the complaint that break down naming names, naming dates of exactly the events that occurred. With reference to the agreement does not require an amendment to the schedule. And on top of that, the schedule is from 2007 before the event. It just requires an amendment. It doesn't say that that schedule has to be amended. So the reach out, and there's correspondence between the parties. It's detailed in the complaint. We will provide that allegation. And you're correct, Your Honor.
So does this go to like the first question that I think Judge Moulton asked about the reasonable reliance? I mean, that you did ask about the seg letter. Did you need another seg letter and you didn't know about it? I mean, is that part of all that? You know, you relied on their expertise in that area, even though everybody was somewhat sophisticated in this general area?
Right. So, yes, Your Honor, because the issue of reasonable, justifiable reliance is twofold. And it's the fiduciary relationship. And it's something Mr. Pecan said is interesting. He cites to Regulation 166.3 and talks about it, which uses the word agent. Right? It's interesting that he's arguing agency for that purposes, but will not argue agency for purposes of the seg letter. Agency creates the fiduciary relationship by its own definition. So he's arguing it applies in one place where it doesn't apply in the other. And on top of that, an agent can still be responsible for fraudulent actions, which burden would not then fall upon the principal. Right? So as for issues of justifiable reliance, we also have the expertise. By becoming a custodian settlement bank, their expertise was the handling of commodity segregated funds for undertaking the action so that they could be a settlement bank with the larger exchange, the Chicago Mercantile Exchange, because of the proper holding of customer segregated funds. And by doing that, they held themselves out that we can do this. If it was a regular bank, they would not be allowed to do this. So all we needed to do was, yes, we had to find out certain things. Was the account properly titled? Did we have a seg letter applicable to the account? Okay, and when we found that out, everything else was in the control of the respondents. There was nothing else that the plaintiffs could have done. And the fact that in hindsight, there might be a suggestion that something could have done wrong. The plaintiff is not required to assume fraud in every transaction it entered into, even if it's a sophisticated investor. And that would be the DDJ management case and the IKB International versus Morgan Stanley case. The burden is not absolute. if you rule differently, what you're saying is a respondent can do whatever they want at any time to a sophisticated investor because somehow they had to dig down and assume that the deal they entered into was fraudulent. Thank you.
Thank you so much. That concludes today's calendar.
Thank you, Your Honors.
Thank you.